Well, the legendary Randy Schoenberg. Well, thanks for joining us. You know, it's funny, but like all kids have watched Woman and Gold, right? So I was dinner table conversation with my girls. I was like, hey, I'm gonna talk to you because they keep asking about who's gonna be on the pod and things like that. Not that they are particularly. I don't think they watch a single episode, but there's like so. So I said, the guy from Woman in Gold, and he's like, so you're talking to Ryan Reynolds?
Right. I know. They're going to be so
real guy.
They're going to be so disappointed when they see this.
They're talking to the real guy.
When they were putting together the film, they asked me, like, who do you think should play you? And I thought, Jim Hill, right? Schlubby Jewish guy, right? Like that would be me, right? And then apparently he didn't want to do it or whatever, and so then they came up with Ryan Reynolds, and I remember they told me, and I gotta say, we're not his demographic. Ryan Reynolds, at least back then especially, we weren't, before Deadpool. It's mainly women who were into him, but I had seen him in The Proposal with Sandra Bullock.
Yeah.
I thought, that guy? Really? That me? Okay. Whatever.
But they put glasses on it.
They put glasses on him to make him look smart, like me, who wears contacts. And then at the end of the film, there's a picture of me, and they added glasses to that picture.
Really?
To make me look like Ryan Reynolds, so they added glasses to Jim. Yes, it's very Hollywood. But it was a good film, and it was the most successful independent film of that year, of 2015, with Helen Mirren and everything. Yeah, it was a big deal, and thank goodness they didn't follow any of my advice. Like, it wouldn't have been successful.
Now with Helen Mirren, did she sort of play the part? Like that was.
She was super nice and really good, and I put
That was authentic. That was how.
I put depositions of Maria Altman on YouTube, and when I met her, she said, "Oh, thank you for doing that. I used that to study her mannerisms and accent and things like that." So she was super nice. It's 20 years ago. It just actually this week is 20 years since the decision in that case.
Wow.
It was January 16th or 17th.
About 10 years since the movie.
And 10 years
like
when he had sentence,
right?
Yeah.
Yeah.
The time flies.
It does. Well,
And I haven't really practiced law much since then.
Well, here's you.
Now I'm back. Now I'm back in first office.
You need you back around right now. You need you back in action. Well, so let's maybe spend it. All of us are plaintiffs, I guess. And I don't know about you guys, but every now and again I'll get some document I need to e-sign. It's like a 23-page document, and I read the first paragraph, and then I'll quote.
Should I be concerned that I'm not getting those documents?
I don't know.
Probably. I don't know. But it's something. But that sort of, when I was e-signing one last week, it's occurred to me that, man, there's a lot that has gone on. A lot of new things have emerged and surfaced. So why don't we sort of unpack it for everybody? I think it could be useful. So maybe let's start at the beginning, so to speak, is if we...
There was a fire.
Yeah.
That's right, there was a fire. There was so if we break down the master complaint, right? Am I using the right language, the master complaint?
What do I know? But yes, yes, it is now a master complaint. It didn't start out that way.
Okay,
But
it didn't start out that way. So
September, October.
So maybe
master
just
complaint.
paint a picture of what that looks like.
Yeah, so to go back to the beginning, there's the fire, and there are a bunch of law firms in California that specialize in fire litigation because we endlessly have these horrible fires all throughout California, and they're very experienced. And so several of the law firms very quickly put together complaints and filed them, mainly targeting DWP for the reservoir issues and lack of water in the Palisades and things like that. And what they did was they got very quickly in front of a judge who declared it a complex litigation case, which allowed them to take all of the related cases, so any case that would be filed related to the Palisades fire, and put them all in front of one judge, and then stop them all and have a what they call a liaison counsel, like a lead counsel, really try the case, so that you won't have 6,000 separate lawsuits being tried. You're really just going to have sort of one consolidated case. So it's not a class action, although there are some class actions that were filed subsequently, and they would like to take over it. There's a little bit of a battle, I think, between them. but it operates just about the same as a class action in that
There's another term for it, like mass tort.
mass tort, complex litigation. It
What
operates
is
the
a mass
same.
tort for the listeners?
So mass tort is just a where lots and lots of people are injured in one case, right? So tort is any type of claim involving negligence, right? Or
Is it in
battery
acronym
or
or
something.
what does it mean?
No, tort. It's not like German torte, right? It's like
It would be a cake.
It's something comes from French. In law, the best thing you can do is quote something in Latin, and second would be French. So it's obviously something French derived. I'm not quite sure what, but it just means you caused harm to someone, basically. And so
Like torture?
like torture is the same root. Yeah, exactly.
Or like a piece of cake, like winning this will be a piece of cake.
Basically torture. Yeah, that's a different one. So in a mass tort claim, and you have it, where there are hundreds or thousands of people injured, they consolidate the cases in front of one judge, so that judge can really know what's going on instead of spreading it all throughout the court system and having chaos. It's makes it easier, of course, for the defense, right? Because instead of defending against 1,000 lawyers, they just have to defend against one, and makes it easier for the judge. It's not necessarily better for the plaintiffs, but it can be also because you coordinate the resources and all of that. So that's how it worked out. It was not my type of litigation that I did back when I was practicing, and but what happened was I was very chagrined by the tactics they were doing in suing LADWP because I was not very optimistic about that claim.
What was it for the audience? What was the?
Well, it may succeed. I may be wrong, and I'm not an expert in this field, but it seemed to me unlikely that that you can make a claim for lack of water in the reservoir. And but I initially, again, not having experience in the field, thought, well, who really screwed up is the fire department, right? And we should look at that. And so I sort of researched that and looked at that, and then talked to a lawyer, and he said, the fire department's immune. I'm like, oh, really? So I was very inexperienced in this, but I am historically okay at researching. And so I did some more research and worked it up, and then realized, well, if not the fire department, maybe the state of California would be liable because they are the landowners where the fire started, and there are rules on when you can sue the state of California and other government entities, and those rules allow you to sue when there's a dangerous condition on public land that is known about, right, and the government has an opportunity to fix it and doesn't fix it. So the classic case is like on the sidewalk is broken and someone reports it and said someone's going to trip, and they just decide not to fix it, and then someone trips, right, and then they sue and say, listen, you knew about this, you knew it was dangerous, and you didn't do anything about it. Give me money, right? And so there's a specific statute that governs that. And so the theory that I came up with, and some of the other lawyers then were moving in that direction, is that you can sue the state of California for this, for ignoring the fact that there was a very dangerous condition on public property after the Lockman fire. So the Lockman fire happened on the 1st. It was then sitting there as what they call a burn scar, and then it rekindled. And this wasn't my invention. I was getting it from the news reports that were coming out in the LA Times and Washington Post, New York Times, San Francisco Chronicle. All of those papers in the first 2 weeks of the fire were putting out articles, and this sort of rekindle theory was being aired, and I thought, okay, I think we can do something about that. And then it turned out there is a case that is very supportive. It's from 1970, I think, so it's over 50 years old. And it's a case involving an airport where the city that ran the airport was held liable, or at least the plaintiff was allowed to sue for allowing someone to store hazardous materials in the airport storage facility without any fire protection. And the court there said there is no immunity, right, even though it resulted in a fire, right, because as the landowner, they have a duty to make sure that there isn't a dangerous condition, and having this very flammable material that could result in a fire, and actually did result in a fire, was negligent on their part. They knew about it and allowed it to happen, and so that they allowed them to sue. So our theory in the case, and it's going to be heard by the judge on February 5th, is that the state of California knew about the Lockman fire, and they were up there and obviously knew that the burn scar was there. They knew, or should have known, that it was.
And the state of
very
California
dangerous.
knew how, because of the state parks and the rangers that would.
Yeah, I mean, it turns out the facts are that they were notified like within minutes of the start of the fire. I think it's just shortly after midnight. It got called in and called the fire department from dispatch, and then called state parks because they knew it was in.
And they also know because members of the fire department, firefighters, said that fire is not out, right?
Right. So it turns out, I mean, these facts are, some of them are alleged in the complaint. Some of them have come out because of reporting in the LA Times and other places afterwards. But it turns out that state parks officials were there on the 1st and the 2nd. Mainly environmental unit was out there, and they were worried about destroying native plants, and there are certain cultural sites in the area and things like that. So they sent people up there when the firefighters were up there, and they had some sort of discussion. And now there's discovery going on now, limited, unfortunately, but there's some discovery going on now where they're trying to determine what the state parks was told and what the state parks told the fire department. But it's clear that state parks was aware of the burn scar, as was the fire department, and then they ignored it. I mean, there's no evidence that after the third, there's some evidence on the 3rd that someone went out there to check on things, but from the 4th, 5th, 6th, and 7th, I haven't seen any evidence that either the fire department or state parks did anything to monitor the burn scar and
Or confirm that it was out, right?
yeah, I mean, they're all saying, and the party line has been from the fire department especially, like it was out, when the only problem with that is that it wasn't. So they haven't really come to grips with
Are
it.
those text messages that I think the Times reported on, right, which is within the fire department itself, one of the guys within the fire department basically sending a text message saying that, look, I don't think this is done yet. Are those helpful?
I mean, I think they're certainly helpful to all of us who want to know what happened and want accountability for it. How it'll play out in the liability, I'm not sure, because that really is then sort of the fire department messing up, and we can't sue the fire department because of the immunity for firefighting. So really, we have to focus on what the state knew, what state parks knew, what they could have done, what they should have done, and that's going to be the question. Now, I think one of the most interesting new pieces of information came on one of the Pali legal chat. There's a woman who posted a picture from 2019 when there was a fire on Palisades Drive. So the Lockman fire, if you go to the top of Highlands, where the Lockman fire and Palisades fire started here, but there was a fire right here in 2019 that burned 40 acres. The Lockman fire was just 8 acres. And after that fire in 2019, she has pictures from her backyard, or her father's backyard, of the firefighters sitting in lounge chairs, looking at the fire. And she said they were there for 2 weeks monitoring the burn scar. Right. So my question was this is not a legal question, but it may play into the legal thing. But it's just a person who lives in this area. Like, what changed in the protocol between 2019 and 2025? Right. Like in 2019, they knew, because there was a Santa Ana event coming, they knew they would station people there 24/7. Like, they were up there all
And they
the time.
knew the amount of chaparral that was present, and
Yeah, I mean, it was just,
Well, it just was their SOP, right? We gotta stay here, watch, and
Yeah.
make sure that if there is a flare up, we put it out.
and how did that change?
But
Anyway,
again,
that
this is
may or may not play into the legal.
because this is more a point of curiosity if you can't really sue the fire department anyway.
Yeah, but it does go to, like, what could people have done? What should people have done, right? So state parks could have called the fire department and say, hey, aren't you going to watch this, right? Or they could have sent someone up. And these days, even more than 2019, it costs, what does it cost to put a camera right? Like
$40.
40 bucks, right? Infrared with drones and things like that. And there is a private person, I think Gary Baum, who set up a drone and took infrared on January 2nd or 1st or 2nd, something like that. So, why weren't they doing that on the 7th, knowing that this big wind event was coming? And what everybody thinks happened now is that the winds started up that morning. There were a few gusts, and just like in your fireplace, when you blow on it, it can
Add an oxygen.
add some oxygen.
Smoldering fire becomes
So
real.
the state does not have similar immunities. They can be sued.
Right. So the state can be sued under the Government Claims Act, which says that they can be sued for a dangerous condition on public property if they knew about it and they had an opportunity to do something about it and they didn't do something about it and someone was injured.
Now, is this cause of action, the dangerous condition, separate from inverse condemnation, or are they
Yes.
related?
Yes, no, it's very, very different. So the theory against the Department of Water and Power is based on inverse condemnation. And that is
What is inverse condemnation?
Yeah, that's a complicated thing, right? And it has to do with, comes in this case from the California Constitution, but a similar action under the federal Constitution. We have a rule, a Fifth Amendment, you can't take property without just compensation, right? So the government can't take your house away and build a freeway without paying you for it. They can do it, but they have to pay you for it, right? So there's an argument that when the government does something and it damages someone's property or takes away someone's property, that they should pay for it, right? So the theory with the with LADWP, as I understand it, and I haven't worked on it like I have on the other case, on the dangerous condition case, I've worked very hard, and I was the principal lawyer drafting the opposition brief. But on the LADWP case, as I understand it, the argument is that the reservoir itself is a public development, and so any sort of damage coming from the negligent operation of that, maybe negligent isn't the right word, but if something happens as sort of a inherent risk of that development, then there's an inverse condemnation case. So there is the problem is there's sort of two lines of cases.
Separate master complaints?
No, I'm just saying on this issue with the water resources. On the one hand, there's over 100 years of case law saying you cannot sue for lack of water resources in a fire. Fire hydrant doesn't work, that type of thing. The firefighters weren't there, whatever it is, that's all covered by the immunity statute. And there's over 100 years of case law on that. On the other hand, the law of inverse condemnation has been developing, and there is a carve out for example, flood dams that cause floods and things like that, where even if it operates as it's intended, but in other words, let's say you set up something where you're protecting the things downstream, but as a result, the people upstream get damaged, right? And so they have all these rules that allow inverse condemnation claims in those circumstances. And so the plaintiffs' lawyers are trying to use that to attack LADWP, and we'll see also after the hearing on the 5th whether that flies or not. You guys like to talk about AI stuff, and so I've been taking the briefs. They're always called briefs, you know that, but they're always really long. And so it's only another misnomer, like tort, right? Aren't so, but they're so 25 or more pages, right? So I plugged them into whatever ChatGPT and Gemini and Claude and all these things, and said, who's going to win, right? And they like the AI likes our claim against the state. Like, all of them say that we're going to win on that. The claim against LADWP, they're mixed. Like some of the programs think we're going to win, others think we're going to lose.
So those are the two major defendants?
Those are the two major defense. There are a bunch of other entities being sued. Some people are suing MRCA, some are suing county, and
The San Juan Mountains MNC.
Does it make sense to sue the MRCA? Because I've heard there's not much money to get, but
That's an issue with everybody.
I mean,
so-
in terms of recovery, there are plenty of issues. There is another theory we haven't talked about, and that's sort of brush clearance theory. And so Again, that's one that I'm not too optimistic about, I have to be honest, because there is an immunity for a natural condition of land, right? And so the brush is sort of a natural condition.
Well,
And so
sorry to interrupt, but didn't MRCA, they sign like some sort of covenant saying we will clear this brush if we buy this land? I thought they were under some sort of legal mandate to do that.
it could be. So there's the issue of whether it's a natural condition, whether they have some obligation. The other issue is causation, right? So like, did that really cause my house to burn down on the beach, right? The MRCA, I mean, they own the beach next to me, but there is one tree on it.
There were
But
tons
it was
of
our,
plants
It was
over
our
there,
house
Andy.
that burned the tree and not the other way around, right? So
Potentially,
so-
though,
so-
without that fuel load, it wouldn't have spread into Malibu, right?
Yeah, I mean, the argument that the lawyers are making is that everything contributes, right? So they have also arguments against water and power, that they didn't de-energize, and therefore there were some electrical sparking. There's some evidence of that happening in the Highlands area, actually, at 10:30 on the 7th. But the people in the Highlands were sort of safe initially, and then all of a sudden were not.
And then there were some other, I think, leaked text messages from the LADWP folks that indicated that
Yeah.
it wasn't de-energized at the right time, etc.
Yeah, I mean, sometimes it's like not the initial crime, it's the cover-up that's the problem. And so both the LADWP and the fire department have that issue, right? Like, they may actually have done nothing wrong, but they're making it a lot worse by lying about it, and so they may end up being found liable because of the lying afterward.
And just so I understand, all these different lines of attack, all these different defendants, are they all going before the same judge?
Right. So yes. So everything's been consolidated. Initially, there was a judge who was going to be retired, and so he did retire. And then there was another judge appointed, and that judge was objected to. And so this is the third judge, Judge Jessner, and she's sticking with the case, and she's a very experienced judge. She was assistant.
And how do we explain feel about the judge?
I think a lot of people like her very much. I've only seen her in a couple hearings. Like I said, I haven't practiced much since the Woman Gold case 20 years ago, so I have never appeared in front of her. But I did go down and hear, and I actually went down one time too early because I put it in my calendar at the wrong time, and watched another hearing on the insurance cases, because all those are also consolidated in front of her. So I got to see how she's handling that. Remains to be seen how she's going to rule on the briefs. I usually reserve my judgment of the judges until I see how they rule on things. But I think she's a thoughtful, honest person. I think she means well, and I hope that she'll follow the law and allow us to proceed, especially on the state claim. So we'll see.
And what are the defendants saying? What has been their response to the complaints?
Well, for LADWP, they have top law firm in the city, Munder, Tolles and Olson. It's just a very famously smart group of lawyers.
Cost shires of lawyers.
Well, my joke about them, I had to litigate against them a couple times, and I said, and they're all sort of Supreme Court clerks, and they all went to the very top schools, and I say, they're really so smart. It's unbelievable. They're almost as smart as they think they are. And that's sort of defines Munger Tolles. Like, they're this level, but they think they're this, and if you can somehow take advantage of that gap, sometimes you can get around them. Their position at LADWP is that there is this rule against suing for lack of water, right? So regardless of the allegations of that reservoir should have been filled and they were negligent in not fixing it, all that, they say, I'm sorry, there's 100 years of case law that says you can't sue over that. And with the energizing or de-energizing case, their argument is that there's discretion there, and there was a wind event, and maybe there were reasons to keep the electricity on. After all, they were trying to evacuate people and get people out and things like that. So when you have an event like that, the most fire cases, Eaton, for example, is a totally different case. It's a much more typical case. There was a defective
Transformer thing.
transformer that
Put
exploded
it on video.
and caused the fire. And that's, the campfire was like that, and all most of these fires,
Woolsey,
Woolsey,
a lot of
Woolsey,
NorCal fires
and like
were
all of these fires are typically caused by utilities, and the trend is to hold the utilities liable so that you spread the cost of these fires to all the clients of the utility, right? So there's that type of thing going on. And so, but this is different. This is, except for that sparking that happened late on the 7th that they have evidence of, this really doesn't fall into that mold. So I'm not
What's
quite
the
sure how
state's
that's gonna
what's
work.
the state's response?
The state-
well,
the
is
state's
it
response
the
is-
same legal group that's representing?
No, so the state so far is not being represented by private attorneys. That may change if we win on the
There are
traverse.
state's attorneys.
So it's the Attorney General's office is representing them, and their argument is we didn't properly allege they have notice, that it's not a real dangerous condition. There are several cases that sort of criticize the reasoning of that one case I was talking about. Vedder is the name of that case, like Eddie Vedder, Edder. That's our key hook. There's some cases that disagree with that, including one that related to one of the Malibu fires. I think the Avedon case, where there were kids or people who were in the cave off of the hiking trail, and so they sued, saying they shouldn't have kept the trail open, and they knew people were drinking beer and smoking and doing stuff, lighting fires at night, and they shouldn't have let people down there, and they said no, the state was not liable for that. It wasn't a dangerous condition that people were allowed to go into the park. That's not true. The other cases they're relying on principally are a case, also might have been in Ventura or Malibu, where there was a road closed and it hampered firefighting access, right? And so people said, well, they shouldn't have had the road closed. It made it too dangerous there, and they couldn't fight fires. And they said, no, the closing of the road was not a dangerous condition that caused the fire. The fire was caused, and then that's all about the firefighting, and there's immunity for that. And then there's a case involving a ranger in Yosemite, I think, who was cooking and started a fire in his cabin and reached for the fire extinguisher, and it didn't work. And so he sued and said, it was a dangerous condition to have a non-working fire extinguisher. And they said, no, there's immunity for that. That's firefighting immunity. Fire protection services are immune. And anyway, so they're relying on those type of arguments. The firefighting immunity statute says fire protection services. It's one of my arguments that I've made in our brief against the state, is that what we're asking them to do with regard to the dangerous condition in the park is not fire protection services, because services are things you provide to another person, but this is something they were supposed to do for themselves, right? So it's not services to the public, they're supposed to stop a fire from starting on their own land, right? So anyway, it's water resources used in firefighting. It's extended. It's going to be a close call. I don't think it's clear.
Just
whether
the
we-
indictment of this guy, I can never say his name properly.
Rinderknecht.
Rinderknecht.
Hinderknecht.
Yeah, although he's
Don't
French.
worry.
He's French, but it's
Yeah.
like Alsace. Right?
Yeah,
Okay.
just
Probably
right
also
in-
is up there.
Does that indictment help the case for us, the plaintiffs, or hurt it, or it doesn't matter?
It's a good question. The state is actually arguing that there are certain things in that case that hurt our case against the state. They say, for example, the fire was his fault, right? He started it, and it was just the Palisades fire was just a continuation of his arson, and therefore they can't be liable for it. So if the court buys that, then that would be.
But what I learned, or we learned in our community brigade training, is that as soon as the fire department takes over the fire and extinguishes it and declares it extinguished, in that moment the fire department takes complete responsibility that it is actually extinguished.
But this is also not potentially
not
legal
for liability.
responsibility.
I don't know.
This is like a moral fire.
This is their argument.
I don't know if it would hold up in court at all.
No, it didn't sound like it's it's a legal thing.
All right.
The
But
law,
they're immune.
Yeah, the law is pretty clear that it doesn't matter who caused the dangerous condition. right? So it could be anything or anybody who causes there to be a dangerous condition. That's not the issue. The issue is that they had notice of it and had an opportunity and ability to do something about it. So that's going to be really the key to the case if we can get to that
So
stage.
February 5th, that's the next major milestone?
Yeah, February 5th, there'll be a hearing. Actually, the lawyers were talking about it today, that there was some talk, especially in the Palisades, about a lot of people going down there and making a lot of noise.
Downtown LA?
Yeah, in downtown. That's probably not a good idea. It's the federal court is sort of a high security place, so it's actually hard to get in, and it'll slow everybody down if there are lots of people trying to get in. And the courtroom itself is going to be filled with lawyers. I mean, already all the hearings have been, I'd say, half or 2/3 full of the seats, and this is a bigger hearing. There are actually more defendants in the case now, so I imagine every seat is going to be taken up potentially by lawyers.
And what's the objective of the hearing?
And the hearing is on what's called a demurrer. Again, that's that French thing that comes into our law. It's just a motion to dismiss, but in California we call it a demurrer. Demurrer, hard to say. And so both the state of California and LADWP have filed demurrers. And if those get sustained, that means the judge agrees with them. It means the case ends. And if it gets overruled, that's good for us, then we get to go forward. And it's certainly possible, it may be even likely, that she will sustain some and overrule others. In other words, she'll stop one part of the case from going forward and allow the other. And then just to get into more of the weeds, but I think it's important for people in the plaintiff class like us to understand, let's say she allows the cases to go forward, both. And in response to that, in general, you're not allowed to appeal until the end of a case, but you can do something in the middle of a case. You can file what's called a writ, and you can ask the appellate court to review a decision because you think it's a really important decision where there's, let's say, a split of authority, and it's sort of a very difficult and important legal question, and they should stop the case and first consider this before we go through the whole process of having a trial and then appealing later, right? And I would think that there would be a good chance of a writ being accepted by the Court of Appeal on, especially on the LADWP case if we prevail. So in theory, if we win in the case against LADWP and they file a writ, again, they have those smart lawyers, so they're definitely going to do that. If they prevail on the Court of Appeal to take it up, that could stall the case for at least a year and a half, I would say, maybe more, and then it could go all the way to the Supreme Court and delay it another 3 years. And we could lose at the end of that, even if you went to the trial court. So my worry as a plaintiff, not as a lawyer, is that there's going to be a lot of delays in this process. But we'll see. We just have to see how it plays out. My expectation is the judge may tip her hand a little bit at the hearing. Sometimes they issue a tentative ruling and take argument.
But she doesn't have to issue the ruling on that day?
No, I mean there's a rule in the state courts that a judge can take it under submission, and I think that after 90 days there's some penalty. I mean, there's nothing really forcing them, but they, in order to get their paycheck, I know this because my dad was a judge, to get their paycheck, they have to sign a statement saying, I don't have anything pending more than 90 days.
It's a good idea to get to the billing department.
For our tender guys and our coastal folks.
That would be very nice, yeah. So my guess is she would take it under submission because these are difficult cases, and
And it's her and only her. She doesn't have a panel to consult with.
no, she has clerks, and judges often ask other judges about their advice on things, but it's really her decision and hers alone, and she'll issue that decision. I mean, it's possible that she rules on February 5th. That would be interesting and great, probably. I think, if it's in our favor, bad if it's against us. But more likely she'll take it under submission, and we'll hear in March, April, May.
Are these,
timeframe.
so there's a hearing, is that the first time she's going to hear a bunch of new information, or is it already in her office?
Yeah, I mean, everything is in the written briefs.
So she's
The
read
brief
all
briefs.
about it, and she's
Hopefully
already
she's
thinking
reading
about
it now, right? It was just, reply briefs were just filed.
Or she's got Gemini?
Yeah, I mean, they have clerks also, and so the clerks may ask, Gemini or ChatGPT or Grok, right? Claude or some one of them, and let's see what.
It'd be interesting to
they
see if each of the search engines have a different sort of vibe.
That's what I was. That's what I was looking at. To
I'm
try.
sure Grok is going to be like, no, you guys are winning.
Who knows?
Like anti-establishment thing.
I'm curious, when there are all these different plaintiffs' firms that are working as one,
Yeah.
in the back room, are there disagreements about strategy? Who's writing the briefs?
Yeah, I mean, I haven't seen that. Again, I'm not in the core group. I'm not one of the liaison council. I'm not in the steering committee. I partnered up with a guy named Bill Daniels, who's a very experienced fire lawyer, and to represent my family. I mean, it's not just me, my uncle, my brother, my cousin, all lost houses and a lot of friends. And so I sort of partnered up with him to do that. And he's in the steering committee, and I'm sort of adjacent. So I've come from as an outsider and unknown. I'm sort of weaseling my way up, and I'm now adjacent to these people, and I can text them and write them emails, and they answer, and so that makes me feel better both as a plaintiff and as a lawyer, because I sort of felt like very frustrated, right, not to be able to be in charge of my own case.
Well, it sounds like you're being very modest about going after the city as being, something that you originated. Right, I mean that could end up being quite pivotal.
Not the city, the state.
The state, I mean,
state.
yes, the state.
The reason I partnered with Bill Daniels is he filed a complaint that was also focused. He was the first one who filed something also against the state, which is something I had been working on, and so I saw that he was going in the
Because
same direction.
at this point, from what I'm gathering from this conversation, that our odds against the state seem to be greater than.
That's my view. I could be totally wrong. Again, I'm not.
Well, just
it's
hearing
very
the
hard to
cases
predict.
that they're citing, you mentioned,
Yeah.
they don't seem that persuasive or that related to what we're claiming. So
That's what ChatGPT says also, but who knows how the judge is going to look at it? And there's a lot of political considerations. I mean, I hope those don't come into play so much, but there's, I've found in my practice it's hard to predict what judges are going to do. When I was doing the woman in gold case, everybody was sure that I was going to lose, and I ended up winning miraculously. So anything can happen at any time in litigation, and you really can't tell. And some things that you think are going to be important end up not being important. Other things that you thought.
So let's play out the two scenarios. Let's start with the optimistic scenario first, that we get an outcome that we all want.
She overrules demurs. Yes.
The case proceeds, and let's just say we win.
And no writs are filed.
Well, okay, so yeah, I mean, whatever.
You're asking for too much.
There's going to be discovery. There's going to be anyway. A lot of things can happen, but in general, the way these things go, as I understand it, is you have the demur first, which is sort of the demur is saying, based on the complaint, you can't make a case, right? That this doesn't state a cause of action that's valid because of an immunity, because of something else, right? So once you get beyond that, then the next stage is in general is summary judgment, right? So you do discovery, which is it's the part I love the best, actually, because it's the lawyers torturing each other, trying to elicit facts from witnesses, and you send requests for admissions. I'm just dying to do that, and the judge hasn't allowed us to do that. And it's because you say, like, admit that the fire started on your land, right? Admit that it was a rekindle. Admit that, right? And then they have to take a position, right? So up till now, they haven't had to take any position, but you can send these things, and if they deny, then you send an interrogatory that says, for every denial, state all facts supporting the denial, list all witnesses, identify all documents. I'm like, I'm just dying to do that. So that's discover. Sorry, it's right. You can see what gets me excited.
April may be the high point of your year.
Once she lifts the discovery stage, then yeah.
I don't know what'll make you happier, a permit on your beach home?
No, they're definitely the discovery. I mean, permit on the beach shovel would be nice too, but that's just the beginning of disaster. But this will be fun. And so you do all the discovery, and then they'll file a summary judgment motion. So summary judgment is different than a demur. Demur say, just take the facts pled in the complaint as true. Does it state a cause of action? On a summary judgment, you actually have to put up facts, right? You have to show evidence. You can't just say, oh, I hope this is true. And so the defense will make a motion for summary judgment saying there's no evidence that we had notice, there's no evidence that we could have done something, there's no, and then we will have to have evidence on all of those points. And the judge doesn't decide the case on summary judgment unless there is no dispute in the facts. Right, so you could win as a plaintiff. You can even win on summary judgment, like happens in breach of contract cases, right? Like there's no dispute that we had a contract, you breached the contract, there were damages, end of story, right? There's nothing to go to a jury about. But in most cases, there's sort of a he said, she said, right? So one person says this happened, the other one says no, it didn't happen, right?
Everybody has evidence.
The
for that.
signal was red, the signal was green, right? And there's a conflict, no summary judgment, then it goes to trial. Right, so these are the stages. It's demur, which is just the face of the pleadings, summary judgment, which is see if there's a dispute in the facts, and then trial, you have a judge or a jury will decide the facts. Now, if I understand correctly from the fire lawyers, what happens in these mass tort cases is they don't have 6,000 trials. If they go to trial, there'll be 1 or 2 or 3 test cases, and how those go will then determine what happens. More likely than not, we won't even go to any trial. If we get past summary judgment, there'll be some sort of settlement discussion, and then each law firm may have a different negotiation. I'm not sure how it works out.
And what is and tell us a little bit about what that recovery could look like from these agencies.
Yeah, so that's to add complication. The biggest plaintiffs are the insurance companies, right? They paid out billions of dollars.
So they'll be the first ones taking that.
So it's a whole other thing, and I'm not 100%, I haven't done this before, but I've been reading up on it and trying to get familiar. So they file what's called subrogation claims. When you have an insurance contract, it's a contract, and they say, we'll pay you X dollars, and then we get your claim, and we can sue on your behalf. So the plaintiff lawyers are suing now for what's not covered in those insurance subrogation claims. So emotional distress damages or any uninsured damages that you have. Like my uncle didn't have insurance because he was dropped, right? So he doesn't have a subrogation issue.
Or a lot of people are
Or a lot of people are underinsured, and so you get to be made whole first. You get your non-economic damages, the emotional distress, pain and suffering, and things like that, plus whatever it is to make you whole above and beyond what you got from the insurance, and then they get their claim also. But that is a whole other.
It'll take years to sort out.
And you're saying that, sorry, there's a priority there? The
Actually,
insurance is at the bottom?
The insurance should be at the bottom, is my understanding. You get made whole. There's a made whole rule. So because there could be a lot of ways of dividing up. I don't know what they do when you settle and you say, oh, I want all the money as pain and suffering. I don't want it as money that's going to have to go to the insurance company. I'm not quite sure how those. I think the judges have to supervise the settlements to avoid that sort of fraudulent screwing over insurance companies. But anyway, it's super complicated. But
So there's a possibility that I could get paid out and have to give part of that to my insurance?
yeah, or you get paid out just whatever isn't going to the insurance, because if it depends on that.
And that'll be a he said, she said of insurance. Well, we paid them that, and that's all they needed. And they'll be like, no, we needed 5 times that.
I think what most of the lawyers have been doing is they ask you, how much was your insurance? What was the value of your house?
So that's what these
they might
law
argue.
firms are really good at, actually, is the damage part, right? So they know, because I've talked to them, like they have their experts that they have psychologists who are interviewing people. This is, if you remember, in July there was a deadline, because you have 6 months to make a government claim for the non-economic damages, in 12 months. So just 2 weeks ago for the the economic damages.
And I think that 12-month deadline was extended too.
I think so. There's some late claims maybe that are being accepted by some defendants, but the state not, for example. So anyway, so yeah, you have these different, a whole bunch of competing claims, but these law firms are really good at managing. Like that's their forte. Is they take in 1,000 clients or 3,000 clients. I think France has the most, right? And they get tons of clients, and it's just like a mill, right? So they have a big spreadsheet, and they make sure that everybody gets all their damage claims together, and so that when there's a settlement, they run the spreadsheet through the through the machine, and out comes the dollar.
So,
it's
neither the state of California nor the city of Los Angeles has a very attractive looking balance sheet, right? So where is this, let's just say fast forward to a very favorable outcome, where's this recovery money gonna come from? Are we gonna,
Super.
Yeah,
Another super interesting thing is that cities can file for bankruptcy, for example. So if LADWP was on the hook and then they didn't have enough money, they could file for bankruptcy protection, and that
fizzles out there?
there's a whole other ball of wax there. States cannot file for bankruptcy protection, so any judgment you would get against the state, they can't really get rid of, and so they would have to pay and figure out a way
more BTA? The BTA is gonna come down to centimillionaires.
yes, something like that. But we're not at that level, and I think, yes, I mean the claims are going to be enormous, but you have to remember, like LA County just paid $5 billion for sex abuse, child sex abuse for social workers and things like that. An enormous amount. It might bankrupt the county. I have no idea, but when we're talking about the claims for all the fire victims, it's maybe 10 times that, 50 billion or something like that. People are saying, I don't know.
just Palisades? I thought Palisades was like 10 billion. And Eaton was like 10 billion.
I don't know. I think it's probably more, but anyway, it seems like a lot. It is a lot, but when you spread it over for state of California, it's probably manageable. Not good for the state, and that's why they maybe should pay attention to burn scars on the day of a historic wind event, right? That would have been
That's right.
the right
the
thing to
right
do.
more
And
prudent
lawsuit or no lawsuit, I am very, very concerned that there has not been any reckoning with that fact. There's been no one held accountable. Not only no one held accountable, but no one saying what they're going to do differently to stop this from happening again. Because I went hiking, by the way. Have you been up to the Highlands? I went to the burn scar on Saturday and hiked through, and it's a foot. It's basically knee-high shrubs everywhere where it was completely burned out, and which is the natural state of the Santa Monica Mountains. And this will happen again if they ignore another small burn scar.
I always think that's worth pointing out, that litigation isn't just about, it's like when Kobe Bryant's wife sued the sheriff's department, and she won a large judgment for the sharing of photos, I think it was. And people said, was great, she doesn't really need the money, and now we're all paying for that. Well, it's not just about the dollars, it's about causing changes in behavior and preventing these things from happening in the future. And sometimes litigation is the best way to accomplish that.
Unfortunately, I mean, I would have thought that someone in the city or state government would be interested in getting to the bottom of this, but
I thought the story on podcast, and I mean, that's well, I think going back to Woman in Gold, that was your central fight, right? I mean, it wasn't so much the company of trainings, but
there was definitely
principle.
because we had initially no hope of winning, but the idea was to tell the story, right, and get the truth out, and so that's
some sort of a record.
that's a large part of my motivation in this, and so I've been talking to the other lawyers, saying, can you ask this question? Can you ask that question? They say, well, it might not be relevant. I'm like, it's relevant to me.
Now let's just say we don't, the other scenario, we don't get a favorable outcome on the 5th of Feb. Where does it go from there?
Okay. Gosh, that's depressing to think about. So if she sustains the demurs, there are other defendants still, but those cases were probably not going anywhere, against the MRCA and whatever the other utilities and things like that, for the same reason that these ones fail. So at that point, the lawyers would have to file an appeal because there would be a judgment against the master complaint, and then they would appeal, and that's a several year process to try to get that reversed. And I would probably be working on it, well, at least with regard to the state claim, because I really do think the state claim is valid. So I would press for that. But yeah, that would be a big setback. And we're hoping that
Where is it at with Eaton? Is it? I'm assuming it's a completely different.
Yeah, it's sort of the same group. I'm not involved in it at all, although I have actually a lot of friends in Altadena who lost their home. But I'm not involved in that. It's the same group of lawyers who are doing it, and that is a totally different thing. And it's much more in the ordinary mold of Edison caused the fire. We're waiting for a settlement, and they make it a settlement offer, and it's not good enough, and that type of thing. But that is heading towards a settlement. I would presume this year.
Wow, so it's on a much faster.
So that has already passed this milestone. The demurrer milestone has already.
I don't even think there's a demur there. I don't know. I'm not sure what the status of the litigation is. I think everybody's just moving straight into that settlement mode. I mean, you read about it like I did, and that's all I know. Also, is that they've made offers to plaintiffs to dump their lawyers and settle by them. Then the lawyers say, "Don't do it. We can get you more money." But that's heading towards settlement. I have a feeling, completely. I mean, what I've been told, it's a completely different.
So in an ideal world, how soon would Palisades fire survivors get a payout, and how long can it take?
Yeah, I mean, so there we're talking about do I get a permit before settlement? Yeah, I hope so. Not really hope so. We may, hopefully get a permit before we get a ruling on the demur. Will my house be built before the settlement? Probably, unfortunately. Wow. I would think. So you figure 18 months to build the house, something like that. I would not expect a settlement coming out of these things for another couple of years at least.
2030, 2035.
I would assume so far away, but that's 4 years.
Because they kind of, if there's appeals, you just get onto a calendar that's way out of everyone's control.
Again, I think the most likely scenario, if the demurs are overruled, or at least partly overruled, is that we get into the discovery for a year or so, then summary judgment motions, which is this big procedure, and then when those are resolved, then you have settlement negotiations. Then
It doesn't go to trial.
then you're like where the Eaton case is now, right? Eaton this sort of okay, assume we're past summary judgment, how are we going to resolve this so we don't have to go to 10,000 trials, right? And so if we get past summary judgment, then the state will have to come in and say, okay, we're going to give you 10 cents on the dollar, and then the lawyers say, no, we need 99 cents, and they'll say, well, we'll give you 11, and okay, and it goes like that.
And those are all kind of backroom deals at that point.
I mean, I don't know if I'll be involved in them, but backroom in terms, the lawyers will be negotiating for their clients, right? So
There's no judge at that point.
sometimes they'll have settlement judges come in, and I think in Lahaina, did I hear that they did that? They'll have a mediator judge come in and get the parties together, and they put them in separate rooms, and the mediator brings them in and say, okay, I'm going to go shuttle back and forth, and he pounds on one side, tells the plaintiffs, oh, you're never going to get that much, and then he tells the defendants, oh, you definitely have to pay more than that, and then tries to bring them together. I say he, but it's generally, generally a guy, but can be a woman. So now Jared and I are down on the coast. How many houses? This is just to fill in for your listeners. How many houses on the coast were burned down?
327 or 30, depending on
Okay,
the
we're a year in, and how many have permits?
One.
So that's not I don't know. I was a math. Most people say I'm not very good at math. I was a math major at Princeton. It's really not a good.
Not a good number.
Not a very good number, and I'm not quite sure how that number is going to pick up anytime soon, based on what I've been encountering.
Yeah.
They're all very nice. Everybody's super nice at the Rebuild Center. I like all of them. But at the decision-making point, it's just not happening, right? Like simple, easy things that should be someone looking at it for 15 minutes are a 45-day process.
And then we wrote down measures like 8A, which we discussed at length at our last pod.
Yeah,
that was one of our big swings.
I watched that go down.
So now we're working at the margins again until maybe the next big swing.
Yeah. Well, we'll see who gets through first. I mean, we just someone's got to figure out the.
So you went up against the United States Supreme Court.
Yes,
And you won.
And Malibu's hard.
And now you're
Malibu's
at
hard.
City Hall with your handouts. Venues.
Well,
I mean, you've a tougher crowd there than William Rehnquist, I guess.
definitely.
Can I have
Because
much
you
you
guys- No, I don't get a fee waiver because I'm just a second homeowner who never rented.
So it's even a no.
Yeah, so I'm not even asking for the fee waiver because I just get lumped in with evil developer, right? Like when you ask about it, say, oh, well, we can't allow fee waivers to evil developers. I'm like, hello, I've had the house since 2007. We didn't rent it a day.
Yeah, but if you may have short-term rental.
That was your choice. You should have maybe. You should have.
Not only not a developer,
Right, for everybody. Well, then it's time this comes around. What we actually learned on this pod is we say so many bad things. We poo-poo short-term rentals, but short-term rentals are the second or third highest source of revenue for the city.
It's a secret kind of highlight. So the next time you see a beer can on the beach, then you just pick it up and put it in the trash and not complain about it.
Exactly.
Appreciate it.
It is.
Appreciate it.
it's gonna be a process. I mean, I've been talking to Darren and keeping him apprised. We have a tract that was built sort of in the 60s, God knows when, by Dunas, and it was protected by a revetment. I had to learn all these words. This is now your field, right? Like revetment.
Those are like rocks.
That's another French
Yeah.
one, right?
Big
It's a
rocks.
reservoir. So revetment is rocks. Yeah, it's like a seawall made of rocks. I don't know who knows.
Often fake rocks, right? Sometimes real.
These are God knows where they
Cement
came from.
bag rocks.
Yeah. God knows where they came from, but they're giant boulders, and so so often they've been repaired. It was actually built in 1960, whatever, early 1960s, and then repaired. I think they tried in 1980, and then in 2000 they went to Coastal Commission and repaired. And because every so often there's a big storm, and the big giant boulders become wobbly and fall over, and so actually are like on the beach. They've fallen onto the beach, right? And so it's harder to walk in front than it used to be. And so now's the time. Like, it was already overdue when the pandemic hit. I wanted to see if I could coordinate, but it didn't happen. But now's the time to repair the revetment because there's no houses, right? So it's
You
easy
can
to
get equipment down there.
drive the big tractor on and cat trucks and whatever and lift the things up, right? You would think that would be easy. It's an existing pile of rocks, and you want to pick the rocks up and put them back.
Yeah. And so when did you start the process? Like June of last year or later than that?
With the revetment, I think we started talking in August, July, August.
And
on it.
the city of Malibu handle this internally, or does it have to go to Coastal Commission?
Don't say anything. Like, God forbid it would have to go to Coastal Commission.
It's under the rebuild, so it's all
Let's
stiff.
hope it is, right? So yeah, I mean, every time you go in, like, is it going to be 110% higher than it was before? Like, it's a bunch of boulders. Like,
Yeah.
who cares whether it's
Bunch of big boulders.
right? Like, in front of our house, between our house, underneath our house and the ocean, right? Like, who cares if it's a foot higher or a foot lower? Like, not
And by the way, probably helping to protect
the septics,
PCH.
all the septics and the
septics. You
PCH.
want to clear the beach so more people can walk in front of it.
It is a win-win, okay, for everybody if we put these back. But oh my God, it's like a complicated thing, and I had to get. I mean, first of all, imagine getting 10 neighbors to agree. Okay, that's the one thing, and some have.
Yeah, you have to deal with 10 neighbors. You have to deal with 12 opinions.
Some have
Well,
land
this
leases.
is, even if they do agree, there's probably an appeal after.
So I got actually 9 in a row, and the last 2 are like whatever, something's gonna happen. But one's selling and one's whatever. They'll end up going. But so I got them to sort of write an authorization, and I said, okay, I got 9 in a row, 9 of 11. Can we start the process? And so that was in October, and I went down and met with them, and they they said, oh yeah, we have to do this and that. And so I got our coastal engineer to draw up a plan for this revetment repair, and that took forever. And finally got that and submitted that, and whatever wave uprush reports I could find, I just dubbed everything, all the historical things, anything I could find, pictures, just dumped it in the portal. And then I went down and said, okay, can we, like, what next? What do I have to do next? And and it took them. I came in before Christmas. I mean, it was holiday period, but it was before Christmas. I'm like, okay, I'm ready to pay or whatever. Do the next step. And they said, oh, we'll send you a bill. So it took them 10 days to send me the email, because you can't actually say until they send the email.
Says, you want to hand the money.
Money.
And
It's like, yes. So then I get that, and then I saw it on the development portal, but I hadn't gotten the email to, like, it says click to get the email. You click and you get no email, right? So I finally got that, like, whatever, January 2nd, and then I came in and wrote, gave them a check, and it's like $10,000. It's not a little amount of money, but I'm fronting everything in the hopes that will help not just me but all my neighbors.
And so it's been reviewed, the proposed plan.
So it's now submitted on the 2nd. We've had one response from Geo. We passed, and all the others have not responded.
Geo was the fastest.
Yeah. There's nothing to do.
They're not involved.
There's nothing to do. It's
They're
rocks
not
on the
moving
beach.
any of the subsurface.
There's nothing to do for any of them.
Coastal's gonna muse over this one.
There's nothing to do. It's an existing
boy.
thing that we're putting back.
And Geo's like, see how fast we are. Look at this case.
What can we ask
We're the
for?
first.
Randy?
But like
Builders.
environmental, like, what are they gonna do? Right?
All
It's-
the rocks.
the rocks are like, and the coastal engineer designed, like, she's a professional. She designed it. Like, it's got to be pretty close to correct, right? How she designed the rock wall that already is there.
If you think about it, right, the contractor is going to go in, they're going to get boulders from
Oh
somewhere.
yeah, they're
or
not going to
just
care
pick
about the
them up.
plans at all. Like, there's no one's going to
the
fall.
backing
They're gonna
rocks
act-
are 5-year-old
With
could be
real
on.
today to build this corrective
Yes,
measure is not going to be anywhere close
Nowhere.
to what's drawn.
Yeah.
Maybe we should do it how it was done in the 60s and
Just show up, dump a bunch of crafts, and say, hey, it looks like it worked.
Yeah, the contractor said he does, like, he's doing stuff without permits for people all the time, like, because not everybody's a lawyer and wants to do it right?
We're only
because
code
you're down and
compliant
moving.
here,
Yeah.
Mr. Schoenberg.
I'm 100% code compliant, right? So I'm like, I just want them to tell me how to do it and get it done. And I keep telling them, like, the low tides during the day are now,
Yep.
January,
This is
February,
the
right?
time.
Like, this is the time we should be having the tractors on the beach at the beginning. And they don't care. They're going to wait until the sun.
Say, okay, next January, 2027. you
Yeah.
can-
Yeah.
But
And in the meantime, everything is exposed to king tides, some
Oh, yeah.
sort of erosion. You can't fix it now when it's easy. Try to fix it
Someday-
in October,
Yeah,
November
yeah.
when it's crazy.
Yeah.
Someday, Randy, we're going to have the Cadillac of building departments. They're going to be so efficient that nobody's ever going to think about bootlegging anything, because why? It's so easy to get a permit, and we're going to have a safer, more resilient city because of it.
I don't know. I hope
Amen.
I hope we can get through it.
that,
Or you have code enforcement drones
speaking
flying around,
into
taking
existence.
pictures, and instantly sending citations for all those, bootlegging conduct.
The thing I'm actually wondering about is the land leases. I don't know if you guys have had anybody on with the land lease. And they're the same issue with the mobile home parks and things like that, because it just doesn't pencil out for anybody to rebuild if you have 25 years left or 30 years left or something like that. So what is going to happen? They have 6 years, right, to do it, supposedly, if they don't extend it, whatever. I actually said that to them. I said, well, they could extend it.
They will not extend it.
So-
But what they could do is just get their planning verifications, right? I mean, that would be what they really should do.
But there's no incentive for the people to do it, right?
Well, they can sell it in 20 years and be like, well, we got this plan verification that says you can build this.
yeah.
We filed an extension for it every time we had to. Therefore, it's still relevant.
The
That actually would
it's
help a lot.
the underground land, the sort of underlying landowners have to really be more proactive, and I'm not sure they are, because they're going to have to make concessions and do things. But
Are a lot of your neighbors?
our direct neighbor, and we share a walkway with him, right? So, and we have an easement where the walkway is, right? So, like, I have to build. Let's say he isn't ready to build, but I've got to build his portion of the walkway.
Right.
So which means I got to get his signature, right? And he's like, I don't want to do anything, right? So
Does he want to sign a piece of paper?
he's done it. He's been okay. He's been okay, but I'm sure there are plenty that are having super serious issues with that. So who knows what's going to happen?
And you're still chronicling all of this on your blog?
I haven't done an update. I think I wrote in August, whatever that big long one, but I've been working on the deburr. but yeah, I mean, there's been no progress really since August. We got our initial plan verification, I think, in August finally, when Lynn, our coastal engineer, finally got her initial thing in, and we've submitted again for, I don't know, you guys know all the words, RDP, whatever it is, and got some comments from coastal. I sent you those, and so now I have to wait for the next iteration. We're actually going on two fronts. So we are presenting two different designs. One if we don't get the revetment repaired, and one if we do.
Right, because if you get the revetment repaired, you don't need a different shoreline protective device. If you don't, you may need it.
Right.
So,
So I'm not waiting. I'm not waiting because I don't know what they're going to do.
Tied to that
I
decision.
think Malibu won't make any decision. They won't help us figure out what to do. So I'm like, okay, I told them like,
Option A, option B.
yeah, and like submit. Hopefully, one of them will get through. 1 out of 325 so far, and that was an exception, right? Because he had plans from a few years
That's
ago or
correct.
something like
Yeah,
that.
they were ready to go. They've
Yeah.
been to
So basically, no one is at the start.
But we're told every week that a couple are very close.
On the because in Big Rock
Maybe
Beach,
they are a
or
couple.
my
Could be
family's
two.
property, only 2 of us have even applied. Right, me and a guy 5 properties down.
Probably-
Nobody else has even
It's
started.
probably the ones further in, the same ones that they cleared first when they were doing the FEMA stuff, right? Like those.
Because they're
Carbon.
Yeah.
Yeah.
Well, I mean, I'll
Thanks
tell
so
you.
much.
Well, absolutely. No, this is a fascinating conversation. I don't know if all our residents, our plaintiffs realize what a significant day
I had no idea that it was the same.
until now. So
Yeah.
we'll certainly stay tuned for that. Please drop us an update so we can spare it for everybody. Everybody should
find out.
Maybe we'll tune you in for just a quick few minutes.
And is the hearing, is it going to be televised or broadcast in any way?
I know
Or
there's
is it like a closed session and you find out the next day?
Yeah, I know that there's a way for lawyers to dial in. I'm not sure if plaintiffs also have the ability to dial in. There might be.
It would be through your law firm, though.
Yeah.
I think it'll be, yeah, I mean,
Do the lawyers share the logins?
I don't know. I haven't done that before. I'm going to be down there, and we'll see. And like I said, I would anticipate no decision on the 5th. So stay tuned, right?
well, no decisions, but there may be some clues that you might be able to pick up, yeah?
And there's,
So I think
in the meantime, there has been limited discovery in depositions, and they're actually still going on. They've been taking depositions of firefighters the last couple of weeks, and there's a couple more coming. So they are getting information. Interestingly, the city is not allowed them to disseminate any of that information that they got this month. They put it under a protective order, but the
City of Los Angeles.
city of Los Angeles doesn't want whatever information coming out. So
But it will eventually, right?
yeah, eventually.
Like in a couple of years.
Eventually, and apparently there's information coming out in the criminal case also, but we don't have access to that yet also. So stay tuned.
Yeah,
It's
well,
always
thanks for taking the
something to-
time, and thanks for doing what you're doing.
So much.
Thank
Thanks,
you,
Randy.
thank you, guys. Cheers.